Hello everyone, I am Dr. Sonal Jain from Department of Anthropology, University of Delhi. In this series of forensic science lecture, we are discussing about the criminology topic, and today we are going to discuss about the victimization and punishment. Whenever we talk about criminology, we talk about criminals, crime, definition of crime, the various crime which are defined under different section. But the person who is being, who is the person who is the victim of crime, today we are talking about those, what is victimization, the definition of victimization, and who are the victims of such crimes, and what punishment should be given, how the punishment is being defined and being given to different persons in different cases. So victimization, we say victimology is the scientific study of victims of crime, which is also a subdiscipline of criminology. It seeks to study the relationship between the victim and offenders, the persons especially vulnerable to crimes and the victims, placement in the criminal justice system. So the victims, any person with whom the crime is being happened, or the person who is being affected by that crime is the victim of that crime. For example, if we talk about the murder, the actual victim is the person who is being killed in that activity, but the kins of that person who is being killed, for example, the husband, wife of that person, the children, the parents, they are also the victims of that particular crime. So, in a particular case, there is no single victim. There are many victims who are being affected by that act. For example, if we talk about the robbery, burglary, that is one of the case where there is financial loss to a family. So, the victim of that particular crime is the whole family. The word victimology was coined in 1947 by a French lawyer, Benjamin Mendelssohn, from a Latin word victima and a Greek word logos. The definition of victim is the connotations of term victim vary in different legal, social, psychological or criminological contexts. Those who have as a direct result of a crime suffered moral, physical or material damage, they are also victim, and the close person relation of persons who died as a result of crime, they are also victims. So, there are two categories of the victims who are directly affected by such damage and those who are in the close relation. So, if any physical threat is being given to a family member, then the whole family is affected by that act. So, we can say that victim, they may differ by the definition of legal, social or psychological acts, but if a crime is being happened, then the whole family or the whole persons who are closely attached to that victim, they becomes as victim. The unwarranted singling out of an individual or group for subjection to crime, exploitation, unfair treatment or other wrong means, it comes under the victimization. There are various types of victimization. First is sexual violence. Some examples of sexual violence are sexual misconduct, rape, sexual touching, sexual exploitation and sexual harassment. They are different in the ways. If a person is touching the private person of another gender, sex of different person, then that is sexual touching. Sexual exploitation is by exploiting, whether they are in a relationship or it is a domestic sexual exploitation. Sexual harassment can be termed as in the case if anyone having their any private photographs or private videos and other person is giving threats to the victim that I will leak your photographs or I will leak your pictures or I will tell people about your activities, then that comes under the sexual harassment. Types of victimization includes the relationship violence also. Relationship violence can be defined as repeated behavior such as threats, verbal abuse and physical assaults involving adults who are in an intimate dating relationship. Whenever we are talking about the relationship violence, it is different from a domestic violence. Relationship violence is among the persons who are not married and who are not having children. These are two persons who are in a relationship which are staying together for a brief period of time or for a long period of time. The relationship violence can occur between two people whether they are of the same gender or of different genders. So, in a relationship violence, there could be certain threats because the other person knows the secret of the first person. They have fights in which their verbal abuse is being used, or some physical beatings or the physical assaults which involve the adults. Relationship violence typically refers to two adults who are not married, not living together, and they have no children in common. And as said, this definition applies to the same-sex couples, relationships as well as heterosexual relationships, whether there could be different gender relationships or between two boys or between two females. Then the different term for the domestic violence is there, where the victim in a domestic violence case can be defined as an assault, aggravated assault. Aggravated assault means using of any physical beatings. Battery. Battery is touching person inappropriately without the consent of another person. Sexual battery is the touching of the sexual parts of another person without his or her consent. Stalking. Stalking is following another person, whether it is physical stalking or it is social media stalking. Kidnapping, false imprisonment or criminal offence resulting in physical injury or death of one family or household member or another. As we saw in the relationship violence, the persons are not married, but in the domestic violence, they are typically refers to the persons who are living together as a family and are married or may have a child in common. Domestic abuse can be defined as the intentional use of force or violence committed by one household member upon the person of another household member. So, the domestic abuse, when we say, it could be from husband to wife and it could be from wife to husband also. It could be from in-laws to the wife, or it could be from wife towards the in-laws also. So, we have to take the whole picture in common, whether the daughter-in-law is disturbing the in-laws or the in-laws are disturbing the daughter-in-law, or whether the wife is disturbing the husband or husband is assaulting the wife. Whenever a case is there, in the case of domestic violence, then the victim should be looked at from the broader perspective. Apart from the domestic violence, sexual violence and the relationship violence, the other types of victimization are the physical assault and battery, hate and bias crimes. Hate and bias crimes are on the basis of where the persons, some physical biasness is there, whether such victims are in any university or any government offices or any private offices where their biasness is there. Stalking, which is very common nowadays. Physical stalking is still less common nowadays, but social media stalking is a lot, where one person stalks another person on all the social media handles, and that could be the sexual stalking also, where the person will send the sexual messages and assaulting another person. Theft, the persons who are victim of any robbery, whether it could be a big robbery or it could be a small theft maybe taking out some money from their purse, or stealing their purse, or stealing their gold items while going on the road. Threat of harm, whether they are receiving any threats either on phone calls, either by writing, either on any messages through direct messages. So the persons who are uh, affected by all these crimes, whether they are hate bias crimes, the stalking, the theft, or the threat of harm messages, etc., they are being defined as victims. So depending upon the Indian Penal Code or the CRPC, various crimes and all the cognizable offences and the non-cognizable offences which we have spoken about also, so they are being defined in our system. Various punishments are being defined. The concept of punishment and the punishment, how it came into being. So the punishment is the concept which came, it involves the pain or suffering produced by design and justified by some value that the sufferer is assumed to have violated. In the previous times, we had this notion that an eye for an eye, but it does not work that way. There are certain criminals who have committed crimes out of rage, but there are certain criminals who have committed crime just because of that moment. So, firstly, the criminal justice system should know whether the person who has committed crime has mens rea and actus reus, and if the person does not have the mens rea, the punishment should not be same for both the persons committing the same crimes. For example, there is a terrorist act where so many persons are being killed, so many persons are being murdered. The punishments are different depending upon the pain or suffering involved in the victimization. So coming to the legal definition, it is a legal or social sanction imposed on individuals who have committed a crime or violated established rules and norms of society. The primary purposes of punishments are to deter future criminal behavior so that the person who has committed the crime should not repeat such crime, protect society from further harm, rehabilitate the offender, and provide a sense of justice to victims and society as a whole. Because the person who is a victim should believe in the criminal justice system that if something wrong has happened with me, other person who has shown this criminal behavior, the society will give him certain suffering so that he will understand whatever he has done was not good. The act was not good. The victim has suffered because of the act. The Jerome Hall has described the punishment in the following terms. It is inflicting pain to some other person, it is coercive, and it is inflicted in the name of state, that is by an authority. Whenever we say that we should not take laws in our hand, because whenever we are victim of such crime, or whenever our family or the close relative is victim of such crime, then our senses behave in such a way that other person should be punished. If the society or the criminal justice system has given proper punishment to the person, then the victims or the relatives of victim, they have a sense of satisfaction. But in certain cases, the victims, they did not get a sense of satisfaction and they try to punish the other person by their own means. So the punishment should be in such a way that the victims and the family of victims, they should see that the person who has committed the crime has gone through the pain and the suffering which they have gone through, but by the legal means of state or the authority or the punishments which are being defined by the criminal justice system. It also presumes rules, their violation, and formal expression of that violation in the form of judgment. It is inflicted upon the person who has committed a harm. The extent or type of punishment is related to the causation of the harm caused. So our Indian Penal Code, it has all the definitions of various crimes. For example, if the section 375 defines what is rape, the act of rape, the section 376 defines the punishment of rape. That if a person who has committed rape in such a way, what type of punishment that person should be given. Now the question is, why the punishment should be given? So there are certain objectives of punishment. The first one is incapacitation. This aims at making offender physically incapable of committing offence again by giving corporal punishment. This involving cutting of hands, making blind, brand an individual on forehead. This type of punishments is not under the criminal justice system of India. They are being followed by different countries, and these system was these type of punishment was being followed in earlier times. Then the reparation, an act of compensating for loss or damage demanded from criminal. The criminal is asked to restore to victim to his state prior to the crime. Maintenance of solidarity. The justification for punishment is that it prevents private revenge and it upholds the move for society. If the punishment is not given to the criminal on proper time, in the proper time frame, then the person who is the victim of that crime, he has the sense of revenge inside him, and that will go the society. If the proper punishment is not given, then the society will not function in a positive way. So for the maintenance of solidarity, the punishment should be given and in a proper way. There are various kinds of punishment. The first one is corporal punishment, the branding, mutilation, confinement, ducking, etc. Second is the transportation, which is the removal of criminal from his country to some other country to a penal colony. For example, in the case of country as India, there are certain prisons in the Andaman and Nicobar Island where the persons are being transported from this country to the jails of Andaman and Nicobar Island. But when we talk about the Human Rights Commission also, then the corporal punishments are not given in our country, and the jails, they are still not being used. Banishment and exile, the order to leave a city or country for a specified term. Fines, this is the most common punishment which is used in India. Fines and the imprisonment. Fines used generally in case of traffic, licensing regulation, considered a minor penalty, and imprisonment, detention till term of imprisonment. Depending upon what type of crime is being committed, the imprisonment is being fixed by the lawmakers who has made the laws and written the punishments of different crime in the Indian Penal Code. That the term of 2 years, 3 years, 5 years and till the 14 years imprisonment is being given, or the lifetime imprisonment is being given to the person, depending upon what type of crime the person has committed. So we were talking about the human ground. The humanitarian theory of punishment says the punishment should be therapeutic. That means to mend the criminal and others by his example. It should not be a corporal punishment. Crime is more or less pathological and criminals should be cured or healed. There should be justice in treatment towards a criminal. They say that the person who has committed the crime, he should understand that he has done a wrong act and he should be treated in a way that he should not repeat this activity. The term of imprisonment should be dependent upon the cure, that is definitive versus indefinite sentence. If a criminal is put in a jail, he should not be released till it is felt that he has been cured or he has realized that he has done a wrong act. On the other hand, if his term of imprisonment is long and if the justice system feels that he is behaving good, he should not be kept anymore. Now, who is to judge the cure? The person should have knowledge of law or psychotherapy or any moral theology, who should understand that the person who was serving the imprisonment has been cured. Then we have to talk about the capital punishment. Capital punishment, or we also call it as the death penalty. Inflicting death penalty upon a person convicted of a serious crime is called capital punishment. For centuries, death penalty was used without thought for justification. In India, for example, forcing an offender to fight lions, trampling him under elephant's feet, dragging him by a running horse. These were the examples of capital punishment which was being given in the previous time when there was king's rule. But nowadays, the capital punishment is given on certain specific crimes, and it has to pass by the governor. Execution was generally public and the methods used for killing were inhuman in the previous times. In India, the Article 21 of the Indian Constitution, it provides that no person shall be deprived of his life and public liberty except according to procedure established by the government. Capital punishment is given only for 7 crimes: murder, dacoity coupled with murder, war against the state, false evidence which results in capital punishment to an innocent person, instigating a minor or an insane person to commit suicide, and leaking out secrets to other countries. So, this capital punishment include hanging in the presence of public is totally abolished, no painful methods are used, and punishment is given only by the governing authority. There are certain controversies related to it. The use of the death penalty is highly controversial and has sparked intense debate worldwide. Opponents argue that it violates the right to life and can lead to irreversible miscarriages of the justice. There is a deterrence debate, which is ongoing debate about whether the death penalty effectively deters crime. Some studies suggest it does not have a clear deterrent effect, therefore it should not be given. Then comes the human rights concerns. Many international human rights organizations and countries have abolished the death penalty, viewing it as a violation of the right to life and as inhuman punishment. And another fact is there could be a wrongful conviction. So, concerns about the potential for wrongful conviction and the execution of innocent individuals have led some to call for the abolition of the death penalty. Then its retribution. Supporters of capital punishment believe it is a just response to the most heinous crime and serve as a form of retribution for the society. Although the capital punishment, it is still sanctioned in India of the 7 crimes which I have mentioned earlier, but there are 4 types of people who are exempted from it: children who are below the 16 years of age, pregnant women, mentally deranged person, and the persons who are above the age of 70 years. All these 4 peoples who fall under this category, they are not allowed to have the capital punishment. The Indian Constitution provides for altering the death sentence into life imprisonment if there was prolonged delay in the execution of death. Although when we talk about and the capital punishment is being granted to any person, there are certain factors which need to be taken care of. There are certain human rights organization which fight for, because there are chances if the person is being wrongfully convicted of this punishment, then this punishment goes in a wrong way. So, to conclude, it is important to note that the use of capital punishment varies significantly from one country to another, and attitudes toward it differ widely. Some countries have abolished it entirely, while others continue to use it as a legal penalty. Public opinion on the matter also varies, and the ethical, moral, and practical aspects of capital punishment continue to be subjects of intense debate and discussion, and we should see from all aspects whether the capital punishment should be given or it should be abolished. Thank you.